I'm Emihle Majikija, and I'm a legal researcher at Section27. We're a public interest organization that works really at the nexus of the law and human rights. We're concerned primarily in access to healthcare, the right to access to healthcare, as well as the right to access basic education. We really view the BELA Act as an important development in our statute books. It's one that we've definitely welcomed. We've always been very pro-BELA Bill, and we maintain that stance, and we eagerly await its promulgation in full, and we really are looking forward to seeing it being implemented. It's one of those, it's one of those moments where it's so incredible to see something that has been an idea for the longest of time finally being, concretized into an act that we can all see, read, and very soon, hopefully, implement. It's a consolidation, really, of different developments that have taken place. Instances where even the courts, including the Constitutional Court, have commented on the different challenges that plague equal access to education in this country. The reason why, or let me say part of the reason why the BELA Act is seen as so controversial is a difficult one really to address, because when you look at the basic education landscape in this country, there are so many issues that are of concern. We still have millions of children who have to use pit toilets, millions of children who still have to, battle with the fact that there's inadequate infrastructure in so many of our schools. And these things aren't just, the product of happenstance. There's a real history that has brought us to where we are as a country. There are laws and policies that have produced this reality where some have and some don't, and it shouldn't be that way. So part of how this is perpetuated, this inequality in basic education, is unfortunately through a mechanism that is supposed to, be an avenue for local democracy to be seen. Because, in South Africa, in our constitutional democracy, we truly prize meaningful engagement with communities. Our laws are not made in a top-down kind of fashion. Communities are involved, and in the making of BELA, like any other law, there's been extensive public consultation. Many people on different ends of the conversation have made representations. There's been robust debate all along, in a period of over 10 years to ensure that everyone's views are represented. But ultimately, whatever law or conduct, as the Constitution says, that is developed in South Africa must align with the Constitution. And equal access to education is one of those. So, part of the controversy surrounding the BELA Bill, if you were to sum it up in one sentence, it's that interesting combination of misinformation and disinformation. I think it's very unfortunate that, this blow up, as some would put it, occurs in an election year. And there's a lot of interesting political rhetoric that gets thrown about everything. And as it happens in this instance, the BELA Act. So Section 4 and 5 speak to what has been a very contentious issue over the past 3 decades, and that is the role of SGBs in school governance. Why is this an issue, or how does this actually manifest? So you will note that in South Africa, we have what some would call a tiered or a dual education system, even within public education. And that comes about, of course, because of our history. There's a history of historically white schools receiving the broader portion of public education funding. What does that actually mean? It means that then in the transition in the mid-90s, in fact, even before our official transition, the apartheid government had started to, make means for parents, particularly white parents, to choose the kind of governance that would then determine how those schools in particular are run. What then happens is that majority parents, over 90% of them, vote for their schools to become Model C schools, which is to say they receive partly state funding, and they're also able to raise their own funds through donations and school fees. And as you would guess it, these are the schools located in affluent, primarily white areas. So what does that then tell you about how SGBs are fighting to retain what they would say is a measure of autonomy over schools? There's definitely a racial element to it. And I think it's very unfortunate that we see this part of the conversation around BELA receiving so much airtime. Like I said, there are so many pressing issues that should command our attention at this stage. But we're looking at how, in many instances, SGBs have chosen to assert that they have an autonomy that can never be fettered with. And there's no such thing in any institution, including public schools in South Africa. So any decisions and policies and even laws that are developed must meet constitutional muster. and at times language and admissions policies, which is definitely what Clause 4 and 5, or rather Section 4 and 5 of the BELA Act speak to, want to really just clarify the fact that school governing bodies in these Model C schools that are making a lot of the noise at this stage are not subject to this uninterruptible or universal and absolute autonomy to decide or to shape who can come into their school environments on the basis of language and other considerations. I think it's important to remember that the BELA Act comes about after about 3 decades of this new legal framework that governs basic education. And within that framework, for instance, if you turn to the South African Schools Act, which is one of the acts that the Basic Education Laws Amendment Act makes amendments to, within that, there are already provisions that make it so that provincial departments of education can intervene. In fact, in court cases such as the Rivonia case, in Emihle and others, the Constitutional Court has even emphasized that the power of school governing bodies is not subject to absolute autonomy, and no one can ever interfere with it, because within the South African Schools Act, there are provisions that specifically make reference to the fact that, in its previous form, before this amendment, the provincial departments of education could actually withdraw the ability of a school, for instance, to determine their own language policy. That was already permissible. What the Basic Education Laws Amendment Act actually does then in this regard is that it concretizes principles that the courts have already pronounced on and that are already acceptable in our law. The only challenge is that you find that the insiders, so to speak, who make these policies, who frame who is acceptable within their school environments, which obviously wouldn't be the black and poor learner, don't really take kindly to that. And that's why the Basic Education Laws Amendment Act is so important. The Basic Education Laws Amendment Act, specifically within clauses 4 and 5, they still allow the schools, in fact, they specifically state that schools still retain their role in terms of formulating education policy. It then goes on further to say that such policies must be reviewed by the HODs within the provincial education departments. Now, a further consideration that we must take into account is that the BELA Act further avails procedural guidelines for how this relationship is supposed to work. Because I think one of the reasons why we'd often find SGBs in provincial education departments before our courts was because there was this tussle to say, no, but this is my jurisdiction, this is an area that I have the power to determine, and it's not yours, so those are constant back and forth. What we then have now is specific guidelines that even tell us how to then resolve it. Should it be the case that, for instance, a school comes up with a language policy, submits it for review, and perhaps the HOD does not deem it fit to proceed with, there's still a remedy that the court can do. Administrative justice in this country is such that, there has to be internal remedies before we turn to litigation. And that's one of the mechanisms that are now built into the education system through the BELA Act. So if a school is dissatisfied with the outcome of such a decision, they may still approach the MEC, for instance. And that applies for both Section 4 and Section 5 as it concerns admissions policies as well as language policies. So when we speak about admissions policies, we're talking about how, so the SGB, in accordance with the South African Schools Act, as we've had it in the position prior to the BELA Act as we have it now, permits schools to come up with ideas to say, okay, fine, this is the criteria of how many learners we'll take into the school. This is the criteria for which learners we then qualify to come into our school. This is the criteria for instance, one of the contentious issues around admissions policy was how schools, in particular Model C schools, who now have state funding, as well as instances where parents have to pay school fees and there's all these donations that are involved that really make that school environment what it is. In those schools, they would require that when parents apply for their learners to be admitted into certain schools, they must provide certain information pertaining to the economic or socioeconomic background of a child. And in that case in particular, in Rivonia, the court held that, that's actually discriminatory because it affords a school the opportunity to say no. you won't be able to pay school fees, and on that basis, we can't take you in. So in that instance, you find that it is this autonomy of the school that is prized over the actual needs of the learner. And that doesn't really seem to be in alignment with our constitution, because we have a specific clause in our constitution that speaks to equality, and you can't discriminate on several grounds, including socioeconomic factors. And in a situation like South Africa, in a context such as ours, where we are very aware of the history of, what makes it so that some schools are so well-resourced and some aren't. We're aware of that. So to actually insist on saying, no, but these are our policies for our children is grossly unfair. And I think it's a spit in the face of the millions of children who still have to endure deplorable conditions in pursuit of basic education. When it comes to Section 5 and, the provisions in the BELA Act that speak to language, once again, I think it's very concerning that our attention throughout these conversations on BELA, since they've been revived, since the President signed and assented to the BELA Act in its current form in September, it is very concerning that our attention must be drawn to those who have resources to make their concerns heard to such a great extent. When the BELA Act has gone through all the constitutionally prescribed processes of lawmaking, lawmaking is a very lengthy process with many provisions for public participation. Outside of, in fact, I don't want to say outside, but there are even provisions made for the public to participate, whether it's through the public provinces, through the public consultations, whether it is through the public consultations throughout all provinces, or be it through our elected representatives who stand for our views because we've elected them, and that is the will of the people. So I'm not too sure if we really should be giving so much airtime to the issue of language. There are so many pressing concerns in this country. Also, this is a bit more of I guess this comment comes from a constitutional nerd of sorts, which is to say that the Constitution of South Africa concerns itself not necessarily with community rights, but it's a statist, individualistic kind of constitution, where then if we say the best interests that what we should be prioritizing on the best interests of the child, it should be that way, rather than placing an unfair amount of emphasis really on the other end of the stick, which is really a minority of people. Model C schools in this country only make up 10% of all schools. And then we speak to the millions of children who really try to, there are children who have to cross rivers to access a school. There are children who, in the face of the climate change that is rocking this nation, will probably not be able to have classrooms in the near future. In fact, with the floods that we recently had in some provinces, schools have yet to be properly rebuilt. We still have children who are fighting for those basic needs. To insist on the fact that in your school, because you have these resources, only your children can go to those schools, it says something about, I guess, Ubuntu in this country, insisting that as long as me and mine, us, the insiders of this privileged environment, as long as we're good, then we don't really care what happens to the rest of society. Interesting also to note that these are public schools that are saying that. It doesn't really hold water. I think let's not get distracted. When it comes to, issues of mother tongue, there are some making averments that, making the argument that it's basically a war against Afrikaans. It's definitely not that, especially if you look at the demographics of the people that would be making such charges. If you consider the demographics of the people that are making such charges, it's very interesting. There seems to be this assumption that Afrikaans is the select preserve of a particular people that look a particular way. But if you actually think about it, South Africa is a very diverse country with 12 official languages now, including sign language. So if you say that then, provisions relating to language policies are particularly detrimental, in fact, are targeted at the Afrikaans community and the deemed, imposition of English as the official universal language of tuition in this country, is a gross misportrayal of the actual situation. It's not only Afrikaner people in white schools that have to contend with this reality. There are schools that offer mother tongue instruction across the country. And what the BELA Act actually says, if you look at Section 5, is that there are several factors that have to be taken into consideration in the making of, and as well as the review of education policy. There are the interests of the community, not just immediately surrounding the school, but the community at large. In fact, the community within the district. So you can't necessarily say that because in this suburb we look a certain way, speak a certain way, and this is what our finances or socioeconomic situation looks like, that, well, since you're not from our neighborhood, you can't come into our school. That's not how the right to basic education works. I don't think that, these developments as it concerns language policy are really shifting us towards the complete and universal imposition of English as a language of teaching and learning. I don't think that's the case. Rather, the emphasis is on the fact. Rather, the emphasis is on the fact that language policies need to be formulated with the needs of all learners in the surrounds of the school. So if in a South Africa, where majority of the learners are black, and perhaps you can also assume don't speak Afrikaans as their own mother tongue, that says something, about how those policies should reflect diversity in our country, It's not necessarily about the imposition of English either. There are many rural schools, for instance, where they'd be taught, if it's in KZN, once again, a product of our history as a country. In KZN, you'd find mother tongue instruction taking place in Zulu. In Limpopo, perhaps Sepedi, Tshivenda, and other languages. I think we're giving undue attention to Afrikaans alone. Also noting that Afrikaans is not necessarily a language spoken only by maybe white Afrikaner persons. The reality is that you might go to a place in the Northern Cape where there's a colored community that considers Afrikaans as, their language that they would prefer for mother tongue instruction. And therefore that means that taking into account, the needs of the community at large within a particular district, it's not necessarily that it is white Afrikaner schools that have to, adapt their policies in that regard. There are many factors to take into account. I think, with BELA in particular, the emphasis isn't mother tongue instruction. The concern does not lie with mother tongue instruction. It's a matter of insiders of these, affluent environments. They do look a particular way, do speak a particular way, do have a particular level of resources that they can mobilize to make sure that their concerns are platformed. There's that. And then there's the reality of the rest of South Africa. We don't live in two countries in reality. The fact is the inequality that makes it so that millions of black and poor learners find themselves in dilapidated schools, find themselves in overcrowded classrooms, find themselves in particular. It's not a matter of happenstance. It didn't just magically appear. It's not a mother's choice or a father's choice. It's not a guardian's choice to, have their child born and therefore born and raised in an environment where, the schools look a certain way. It's also a product of historic underfunding of schools in, primarily in black and poor areas. I think to illustrate that point, actually, you take us to a very interesting case, which is a locus classicus, just to say is the main case to look at when you want to talk about language policy and what it means when schools have to, accommodate other learners who don't really speak the main language or the first language of instruction that has been determined within a particular school. In that case, what's interesting to note, when you read it, the court really points out the fact that, in as much as there's that matter of, no, but now if you say that we need to accommodate learners of different languages, it places constraints on our resources. We don't have to do that. We've chosen as this community, this is the language of instruction in our school. The interesting thing in that case is that it was a school that had capacity for 2,000 learners. But over the years, they only had just short of 600. And yet they still insisted on not accommodating a number of grade 8 learners who needed to be absorbed into that school or face not having a place altogether because the nearby English medium school was at capacity. Now that brings us back to that point of how it's not a concern with mother tongue instruction when you really critically assess the situation. It's not a concern with even capacity in most instances. What we're contending with is the fact that all institutions in this country, all corners of society need to come to the party, and join hands even with the states. Because, for instance, in that particular case, the state had approached the school, asked them to take in these learners who had to be in that instance, accommodated with English medium instruction. And the school simply refused. That's why it's so important then that the courts have consistently emphasized that SGBs don't have, unfettered autonomy to decide language policies or even admissions policies. So the courts have constantly emphasized the fact that you can't just rely on the fact that, no, we can't accommodate these learners because we have to deviate from our policy. Ultimately, the Constitution trumps all policy. And that's what the BELA Act does. Then it just aligns our understanding of what the role of SGBs and the role of the provincial departments of education in determining all these policies are and what you can do, because there are still avenues for recourse or review where a particular school or SGB feels aggrieved with the outcome, where a provincial HOD in the Department of Basic Education hasn't unreservedly accepted the revised policies. Another very important aspect, that the BELA Bill introduces that really should command our attention speaks to safety in schools. When it comes to private schools and homeschooling, we tend to assume that those environments are, offering education of a better quality, that environment is better resourced, that learners are actually learning, which in our work and our research we've often found not to be the case. So when you look at the BELA Act, we laud it once more because it makes inroads in terms of regulating homeschooling a bit further. It speaks to the fact that it further encourages oversight. It puts in place a legal mechanism, or I guess procedural justification, for the Provincial Department of Education to intervene and oversee and make sure that even if a parent opts to homeschool their child, it doesn't work to the extent, to the effect that even where a parent opts to go with homeschooling for their child's education, it should never ever work to the detriment of the child. Another provision within BELA that speaks to the formal incorporation of grade R into the education system, that in itself is an incredible development that we should all be clapping for, turning our eyes to, because we've had these conversations and concerns really about poor learning outcomes in this country. I think over 80% of learners at grade 4 level still can't read for meaning. So when you look at the incorporation of grade R, it kind of offers a beginning to a response that will ensure that the foundational nurturing and education of children puts them in better stead to improve, so that by the time they get to grade 4, those stats have changed. That's what we really want. There are so many incredible developments that we could find in BELA if our eyes were not so focused on the wrong things. No, taking away, I suppose improving oversight and improving the prescribed procedures to enable provincial departments of education to ensure that no learners are excluded from certain schools because they don't look a certain way, they don't speak a certain language, they don't come from a particular socioeconomic background. Allowing provincial departments of education to say no to SGBs and their policies when they have the effect of basically saying, no, everyone has the right to basic education. Everyone has the right to basic education, except for those people who don't speak our language, don't reside in our neighborhood, can't afford the same things that we can, including school fees, when there should be fee exemption policies, especially in schools that are funded by the government, things like that. So for there to be procedures prescribed to ensure that that doesn't happen is not an unfair incursion into the autonomy of SGBs. There is no institution in this country, including public schools, that enjoys the right to just, autonomously make whatever decision they want to, regardless of the outcome. If we turn back to our constitution, it emphasizes that any law or conduct that conflicts with it or does not, meet constitutional muster cannot be upheld. That's simply the case with the BELA Act in sections 4 and 5. What tends to take place with the inclusion or accommodation of learners who speak different languages apart from the main or primary language of instruction is that then there's introduced another stream to cater for those learners who then, for instance, speak English and be comfortable being taught in English, better poised for success if they're taught in English as opposed to being taught in Afrikaans. No one is arguing for the complete evisceration of Afrikaans as a medium of teaching and learning in this country. That's not the concern. Once again, our attention needs to be drawn to the fact that no child, regardless of race, regardless of socioeconomic background, regardless of any factor really, can be discriminated against. It's in our constitution. So our focus shouldn't be on insisting on the fact that no, but this is, I guess, my house, my rules type of thing. I don't think that's where our focus should be. Our focus should be on the fact that as a country, we've committed ourselves to the transformative ideals of our constitution, part of which means making sure that the best interests of the child take precedence in every matter concerning the child, as well as ensuring that we all participate in transforming this country. A basic education system where you can arbitrarily decide that because you don't speak my language, you can't come into my school and therefore you can't exercise your right to basic education it doesn't make sense at all. One would hesitate to make a comment on whether or not, the BELA Act poses a significant threat that will bring the GNU to its knees. I think once again, we're looking at the wrong things. It should actually be an indictment on parties who say that, or rather not, and by parties, I don't necessarily mean political parties, although they're also involved. It should be an indictment on those who insist on saying cultural rights or language rights matter more than the best interests of children who may not belong to our cultural group or our language group. I think we should perceive it in that light. And that's something that our courts have also emphasized many a time. In fact, it's something that it shouldn't take a court or a legislative amendment to, hammer it home, to bring it home. I think it's an indictment on our society. It says something about the rate and status of transformation in this country, that we have to be having such robust debates about, making sure that all children can access schools and that no one is barred from accessing particularly a well-resourced school. We can't be complaining about schools that are, in a terrible condition, and at the same time, lambasting the government for that. But at the same time, saying that, no, you can't come to our schools, though the government is not doing the greatest of jobs, but you also can't come to our schools simply because you're not like us. That's not an argument that holds water, be it on a moral level, a constitutional level, or otherwise. Section 27 stands, unreservedly behind the BELA Act in its current form. We're definitely monitoring developments in that regard, eagerly waiting to hear from the presidency on how this matter will unfold. I think all members of society, whether you're a parent, whether you're not, whether you're a learner, whether you're not, at some point you must have been. I think we should all make it our business to reflect on the state of this nation and insist on the full realization of the right to basic education, the right to healthcare, all of the rights for all people, regardless of whether or not you speak my language. Shouldn't be a reason for you to not be able to access, services that you need for the realization of your constitutional rights. That this is a conversation we're having is, severely concerning.